Well,
I need to get you to sign that release form.
I want to thank everybody for coming. My name is Rick Harris. My Tlingit name was given to me by Clarence Jackson and Dr. Walter Soboleff on Dr. Walter Sobeleff's 100th birthday. And it was Ka. And I am the Tlingit Haida a eagle from the Dakl'aweidí clan from Cape. A couple of real quick business things first. Out front is a sign-up sheet, so it'd be nice if everybody can sign up on that. There's also a little donation box that's intended for funding to go to programs that help develop Northwest Coast art. And if anybody feels inclined to provide a contribution, that would always be greatly appreciated. The other thing I need to cover is Celebration 2020 is coming this year, so I'm told to remind everybody. And that's June 10th to 13th, so be sure to put that on your calendar now. And if people are coming, make sure they get rooms early. The Dr. Thornton from the Dean from UAS Arts and Sciences indicated this is a lecture series and you get credits. So any of you who are looking for college credits, talk to Dr. Thornton right there. Put your hand up, Tom. Oh, sign up. Okay. Oh. That's so. What I'd like to do is introduce Chris McNeil, and I've actually known Chris for a long time. I came to work in Sealaska in 1980, and Chris was, I believe, there at that point in time, or very shortly thereafter. And so I've worked with him on a variety of capacities, which was always a rewarding experience. Just a personal observation. He's an academically interested person. He digs deep into things, and it's always wonderful to sit and talk with him. But he is the owner of Native Strategy Group, which provides advisory services to Native organizations. Chris' Tlingit name is Shaakakóoni.
Yes.
Sorry. Shaakakóoni of Juneau. He is an eagle, Dakl'aweidí. He is also a citizen of Nisga'a Nation. He served as the president CEO of Sealaska from 2001 through 2014. He served as Sealaska in varying officer capacities from 1978 through 1993, including executive vice president and general counsel, and as a member of the board of directors from 1998 through 2000. Chris had other significant positions, including special counsel, the Alaska Federation of Natives, chair of the Native American Rights Fund, or NARF, the first director of the American Indian Program at Stanford University, second vice president of the Tlingit Haida Indians of Alaska, director of Gold Belt Incorporated, director of the American Indian National Bank, president of Juneau Tlingit and Haida Community Council, chair of the Tlingit Haida Regional Housing Authority, Washington representative and counsel to the Mashantucket Pequot Nation of Connecticut, and the chair of Native American Contractors Association. With that list of accomplishments alone, he's 100 years old. Chris earned a law degree from Stanford, a master's in political science from Yale, and a BA in political science from Stanford University. He is also an inductee into Stanford's Multicultural Alumni Hall of Fame and is awarded the Henry Rowe Cloud Medal from Yale University Native American Rights Program and the Alaska Federation's Native Citizen of the Year. Mr. McNeil and his wife Neri established the Judson Brown Scholarship Endowment, an award given annually to an emerging leader. And I will also say that Mary, in her own right, his wife, has a long list of accomplishments as well, which I won't go into, but if you ever ask Chris what Mary did, she also was a very accomplished person. Mr. McNeil.
Well, thanks so much, Rick. I do appreciate the opportunity to be here and to be able to discuss the Tlingit Haida case, which is the Tlingit Haida Indians of Alaska versus the United States. It's one of those things that's sort of a foundational event for all of us. It's something that's there, don't often get the chance to actually go back and look at it, and not only the case itself and what the decision was, but really what place and what role did it engender insofar as Alaska Natives, Alaska Native leadership, and its various impacts. I think it's important because the judgment was really a pivot point, and it was a point between a theory of Indian claims that existed at that time, that the only recourse that there really was to be able to go to the United States Court of Claims, and the ANCSA model, which is basically to petition Congress to resolve these claims and have lands transferred back. And so that was a very different point in our history. And certainly in 1929, when the A&B met to consider this, it really was the only course that existed, at that moment. One of the other things I'd like to do here is to be able to describe the legislation that was authorized and to place it insofar as the Indian claims and the U.S. history is concerned itself. The case, one way just to lay the foundation of it, what the results were, is that it was because of takings, and these were actual takings that occurred in the turn of the century. And Tlingits and Haidas really bore the brunt of the fact that this was a place where there was much more non-native presence than other parts of the state. So therefore, the activities of resource extraction, principally from mining and fisheries, occurred during that time. And that is really the causation, because it was like the first measure of involvement between, in big numbers, between Alaska Natives and non-natives. And the takings that actually occurred here, I think pretty well known, is that the creation of the Tongass National Forest, which was about 15 million acres that was laid out in the claim itself. And then later there was about 2.5 million acres that was taken for the creation of Glacier Bay National Park. Interesting, something I'd totally forgotten about, there was also a measure of taking for Annette Island for the establishment of the Metlakatla Indian community from Canada, and so that was also part of it. But when you add it all up insofar as the case is concerned, it directly accounted for 17 millions of acres, and that was the claim. The result is that there was a money judgment for $7.5 million, and it really allowed the Tlingits and Haidas to be able to work with and create the Tlingit Haida Central Council as an operating entity to fulfill other goals. But the result is that Sealaska ended up being created and achieved 376,000 acres approximately of land out of the 17 million. And the math on that is it's about 43 cents an acre, that was finally recovered. The agreement also stipulated about 2.6 million was essentially not in the claim, so it meant it was resulted for a later moment, which meant that it was included as a basis for participating in the Alaska Native Claims Settlement Act. There's a kind of a broader historical context, because there really were three ways of resolving land claim settlements in U.S. history. The first is treaties, which is well known. Second is the Court of Claims, of which I'm here to describe today. And third is basically a model that almost stands by itself at this point. You have ANCSA, and then you have the main claims, which followed the Alaska Native Claims Settlement Act by a couple of years. but those two models were very close to each other. And so the treaties was really an agreement between two sovereigns, and the United States recognized that the Indian tribes were separate sovereigns and had separate powers, and so they were looked at that way. And that was severed in 1871. And of course, by that time, Indians were not the kind of political and actual military power that existed in the early part of treaty making. And so the Congress basically changed the status of Indian tribes, because they said they're Indian tribes, but they didn't look at them anymore as independent nations, tribes, or powers, and therefore rationalized the idea that they were no longer qualified to enter into treaties anymore. And basically those treaties not only described the lands that Indians would keep, but would describe the terms and conditions that they would exist on those lands, and whether there are other compensations like the provision of health care and education that would be part of it. And then you have the Court of Claims efforts, which basically changes the whole idea here. It's basically indicating that those lands were taken. Now the question is, you have to make an offer of proof, that they were taken, and how much were they worth, and would the United States pay something for it? And that is the basis of the Court of Claims. And then you have ANCSA, which I just indicated, and basically that idea was a political decision that was made by the Native people, the state of Alaska, and the United States Congress, and basically that became an agreement about which lands were ceded, which lands would be kept, and the structure of how they would be operating in the future, which is ANCSA itself. And you can see by that description, the treaties and ANCSA, have a lot of common elements, but they have different names. But it still was a authority, the plenary authority of the United States was necessary to be able to do both. So following this path, it was very interesting looking back on this, because you think it was in fact a long time ago, looking at 1929. But it really was quite an extraordinary moment for the Native leadership at that time to be able to conceptualize, a model of being able to find some justice in making a claim. And the way that is set up as a matter of legal process is that it required three things in order to, and they all had to be successful. Number one, there had to be a petition to the United States Congress to create a jurisdictional act. And a jurisdictional act was necessary because, the United States is sovereign. You can't sue the United States unless you're given permission to do so. And Congress is the one who provides that permission. So Tlingit and Haida people had to go to Congress, initiated in 1929, fulfilled in June 1935. It took all that time to get, just a very short bill to go forward. And then the second part of it is that there was a trial on liability. So what Native people got as Tlingits and Haidas was essentially the right to sue. It didn't say you won. You can ask yourself about, why Congress would do this. We didn't think it had an obligation, but you had to prove, that in fact there was a taking, and that these lands, had values, and then the third part of it was in the Court of Claims was to determine money damages through that. And you'll see in this description that even though there's kind of a bright line between the two, there really wasn't, because the actual judgment on money damages curtailed some of the judgments on liability that had been made by the Court of Claims. In In 1929, the leadership wanted to have the land. They discussed that. That was something that they wanted to be able to achieve. But it became kind of evident to them that there was no known path. There was only this one path that, had any hope that they'd be able to proceed that way. And so they did. And they wanted to be able to, they felt very confident that they could prove these lands were taken, that they ought to get compensation for it. Interestingly, they had discussions with Judge Wickersham, who they said, well, he's the one who also suggested this course of action because he's quite familiar with, these kinds of processes. And they decided, as they authorized the action, that first they would select counsel, and they select William Paul as counsel, and he in turn wanted to associate himself with Judge Wickersham, recognizing that Judge Wickersham had quite a bit of experience in this. And that was a very interesting thing, because keep in mind that the rules for Indian tribes at the time, specified that basically you wouldn't do anything like this unless you had the permission of the secretary first, because it was the way they saw their fiduciary relationship at the time. And ultimately the court, this did have to be concurred in as well by the secretary. But nonetheless, the Tlingit and Haida people were very assertive about what they thought should be. And this was one of the things that they did. One of the things I also want to mention, I think, especially for the students in the room here and who can think about this stuff, is, who were the leaders? And that's like a subject of a whole separate study, because it was a remarkable thing of a combination of both very young people and elders. And I was thinking this, and particularly because of my uncle Judson Brown at the time, and he was a secretary of the A&B convention at 1929. He was 17 years old. And when he was a secretary for the concurrent A&B and ANS 1935, well, he was 23. And you look all through the land claims, you see this, because, for example, Byron Malott, he was 27 when he was a commissioner in the state government. Willie Hensley was 21 when he got elected to the state legislature. It's kind of an aside, but it's an interesting story insofar as the people where you had very young people and elders, and they put a strategy together, to make it work. I think it really shows, the energy and the intellect to be able to do this. The Jurisdictional Act itself was very carefully framed, and it stated that all claims of whatever nature, legal, equitable, which have against the United States for land and other tribal or community property rights taken from them by the United States without compensation, therefore, or for the failure or refusal of the United States to compensate them for said lands and other tribal or community property rights, claims to be owned by the said Indians and which the United States appropriated to its own use and purposes without the consent of the United States of said Indians, and for the failure or refusal of the United States to protect their interest in lands or other tribal community property. That's a lot. It basically is saying that not only is it a question about taking, it was saying that the United States had an obligation to protect the property interests of Native people. And it's especially fascinating in the fact that the whole idea of trust responsibility, runs through this day about what it is and what the obligations are. And here, the Congress, very clearly contemplated that the United States had an obligation to protect, and if they didn't do so adequately, then there's a separate claim, for that event. But it's very evident from the way this was crafted is they wanted to make sure that whatever happened, there are no more claims. They really wanted to be able to close the door on that, and you don't have to read between the lines to understand that this was the idea. One of the other elements of the Jurisdictional Act, which I think is really quite interesting, I think flows in other cases as well, is that the Congress really declared that all documents are available and accessible. And you can kind of see this even in today's debate with President Trump and impeachment and stuff. What's there? What do you have access to? And basically, Congress said that all documents that are in the control of the United States would be made available to both parties. And so that there would be, at least from an evidence standpoint, there wouldn't be any hiding the ball on this. And so I think it's really quite important. It took quite a while, to get to the trial on liability. So, you think about 1929 initiating action, 1934 getting a Jurisdictional Act. Well, here it is, 1959, and they finally, adjudicate liability. And that's a long road, when you kind of think of it in time to be able to accomplish all of this. The result of this was that when you look at all the claims on liability, the Tlingit Haida people did really quite well, because the United States, even though the federal government fought very hard against all these claims of liability and scope of liability, nonetheless, the decision on liability was really more favorable than not. What I think is very interesting about how they described this liability is the court went way out of its way, or the commission went way out of its way, to be able to describe not just the land. It wasn't just a map exercise. What they did is they went through and described all of the elements that they knew about of Tlingit Haida culture, and what kind of economy existed, what kind of life people led, right down to an appreciation that there were very important distinct rules of the clans. That the clans owned all this property, and it was pretty evident, where this property was and who could use it and who couldn't use it. It did happen to meet all of the legal standards that were necessary in the Court of Claims case. That they had to show that there was, continuous use and occupancy to the exclusion of all others, and that it can never been abandoned. When you kind of think about how that would be proved, that really wasn't the main issue insofar as the findings on liability were concerned, because there was so much evidence, that this land had not only been owned but continuously used since time immemorial. And I think that's one of the highlights of the way the commission, crafted their description about the claim. The commission, they concluded, I thought was a good couple of sentences, that the social organization, the propensity for trade, the industrious character of the Tlingit and Haida Indians impelled them to use to the fullest the many resources available and accessible to them in the claimed areas in southeastern Alaska. That's a pretty broad statement, about not only who was here, but how the property was used, and the fact that this land was exclusively used and occupied. one of the issues that they dealt with is that the United States made kind of an absurd argument. They said because the Tlingit Haidas in the Tlingit Haida Central Council were not organized as a tribe as they understood tribes were organized in the rest of the United States, that they said that, well, of course, Congress has declared that they're recognized as a tribe for the Jurisdictional Act, but they're not a tribe for damages. So we're kind of saying you're a tribe for this purpose, not for others, that you're a tribe if we take the land away, but you're not a tribe if we have to pay. That's essentially what they came out with. And it was an interesting, it was a surprise to me actually to read exactly, how they made this argument. Well, the commission did agree with it, and of course it's, pretty upside down argument, because, why would Congress enact Jurisdictional Act if they didn't think the subject tribes would be able to make, be paid? But that was the claim that was made. One of the other key points about the claim is that they moved next to the issue of damages. And on liability side, they said there was a claim for the loss of fisheries rights. And that was really based on the inaction, essentially a breach of trust responsibility of the United States in allowing other third parties to be able to take the fisheries and use them without any kind of compensation. So they moved to the next phase on damages, and it was really quite interesting how they did this, because on the overall part of it, they did what, it's kind of a garden variety of definition of valuation for fair market value. Essentially, they said, well, fair market value at the time of taking. And that really means, a willing seller, an informed willing seller and buyer would make a decision about the value. And so on its faces, seems kind of reasonable, because that's kind of the way you would do it. But when you look at the actual decision, essentially they qualified fair market value, because the fair market value they decided was applicable was actually not the fair market value that an ordinary buyer and seller would take, because they limited it in some very important ways. One is, they said that if you take any area of land and you knew there were, say, two values, you knew there was there were all these trees on the land and there was a mine under it. Ordinarily a regular buyer would look at that and say they'd make some decision of that. There were two values involved here, or it could be three or four. But the court said that they're only going to value it based upon the highest and best use in their judgment. And so whatever that land could have been used for one thing, was the value that they would choose. And of course, when you do it that way, you leave a whole lot of values on the table because you're not considering them as contributing to the ultimate value. One of the other things that they did that everybody here knows a lot about is, and we do, is standing timber. They actually just attributed a de minimis value to the standing timber. And what's more, at the time they did this, it was well known about how you could value timber. I mean, the industry's been doing timber cruises since just about forever. And in a timber cruise, you measure the area, you measure the volume, you measure the species and grades, and you can come up with a pretty good idea about what it's worth. Well, from their perspective, there was only hemlock. And hemlock even then was the lowest value timber of all. And even then, especially thinking of the World War II time, a lot of old growth spruce was taken out of here for military purposes, for construction of airplanes, because, it was a light, very strong wood. So it seemed pretty disingenuous to me that they would, frame this and essentially say that, look, it's just really not worth very much money. And so they paid accordingly. And when we look at our, we can know the history of this from Sealaska, because for a very long period, a very small percentage, like 1% of all the lands conveyed under ANCSA, we were a principal distributor of revenues under Section 7I. So it gives you an idea about, the scope of what was there versus, what they compensated for at that time. And this is one of these cases where you knew they knew better, but this is just a judgment, that they made. The other thing they did in regard to mining is they recognized that minerals had a value, but the standard of application of it made it such that basically there was no value, for mines, because they basically said you had to have a mine that was really highly profitable, or you had to have a prospective mine which the values were such that you could attribute, a lot of money for it. They also essentially, the underlying thing is concluding that, the capital that's necessary to build a mine is such that really that's the value, not the minerals there. And the minerals they considered to be really of the speculative value. But it had seemed to me that really the bigger part of all of this was the high contrast between the liability decision and the damages decision in regard to fisheries. Because the liability part of it was clear. The commissioners there looked at this and they said, well, obviously, the fisheries hugely valuable renewable resource, and that's what Native people depended on. In fact, a lot of it had gone down by that time, and it really underlined the whole thing. The court on damages, or the commission on damages, essentially said, that's not part of it. And they had a number of theories to buttress this. They effectively reversed the liability court's decision without saying that they reversed it, because you just don't have penny damages for it. Well, it didn't have any value. They'd also indicated that the value of fisheries was in the navigable waters in most cases, and that the lands that were pertinent to it, it just didn't make any difference. Even though that the values taken out of southeastern Alaska were all fish traps that were affixed to the land. That's how they worked. But more than anything, they looked at the Jurisdictional Act, which said that there could be compensation for tribal community property. And this is the obvious place where you could say, well, this was a community property. Everybody had access to it within the village. But they essentially said it wasn't tribal community property. And that was the bottom line of how they kind of got around that. It was a huge setback, because the court had said there, with the inclusion of the fisheries, it would about a $15 million and a half settlement. Of that, 8.4 million of it was attributable to fisheries. And so you extract that was more than half the possible settlement. And so they, essentially that was the decision that they made on that. So at least today, and trying to put myself, I guess, in the position of, what a reasonable person would make on valuation way back then, or way back then being 1968, or the period from 59 to 68, there's no doubt in my mind that there were known ways to value this property, and they just chose not to do it. So the values end up being really quite radically low from what would exist. But nonetheless, the Tlingit Haida people accepted that judgment. It was $7.5 million. And from that, they built the Tlingit Haida Central Council into what it is today. It provided a basis for the government, for village economic development, and even for federal contracting. Tlingit Haida did some of the very first federal contracting with the BIA to supplant their role, which was later authorized by the Indian Self-Determination Act in 1975. So Tlingit Haida was doing this kind of contracting in 1971 for education and other services. So, the settlement, provided a basis for being able to do that. It also provided a basis for being included in the Alaska Native Claims Settlement Act because the claims were not completely fulfilled. They were not. There was the 2.6 million acres that had not been adjudicated, which essentially was a manner to be able to be included in it. But there was quite an impact. Among them, it has seemed to me that it really did help pave the way for the leadership of the rest of the Alaska Native community in the Alaska Native Claims Settlement Act. It did, among other things, make it clear that the basis of the Tlingit Haida judgment is that there were Aboriginal claims that had value and the United States was willing to pay for it. And that really was a big boost insofar as the Native community was concerned, because they could see, that the U.S. was willing to pay, and they were willing to create a negotiated deal, which they did. And I think that was one of the very important impacts of the Tlingit and Haida judgment. One of the other things that I think is very significant is that they took this, the Tlingit Haida people took this to Congress in 1929 and got a Jurisdictional Act. AFN, could see, or the leadership could see that was possible. You could actually go do that because there was just evidence, that this was a sound theory. And I think one of the most important elements is that when the Alaska Native Claims, pivot point with the Alaska Native Claims Settlement Act was Secretary Udall's land freeze. That was informal and it got formalized as he was going out the door in his tenure in 1968, but basically stopped all land transfers in Alaska. So all the state rights to make these selections were put in abeyance to do that. Well, the Tlingit Haida judgment, I think was an important foundational piece to that as well, because it basically was meant to protect the Aboriginal claims, and these were claims, that were very well described and adjudicated in the Tlingit and Haida judgment. And there are other things that I think are interesting insofar as the, sort of the broader impact of the Tlingit and Haida judgment. And one is that the impact of social science methodology to help analyze and describe congressional remedies and formulas. And I see there are three pieces to this. One is the this sort of the granddaddy of all this is the book and study called The Problems of Indian Administration, 1928. It was commissioned by the Hoover administration, and it's better known as the Merriam Report. In my family, I've got some association with this because my wife Mary's grandfather was the only Indian co-author of that book. But it was really important because therein lay the foundation of the Indian New Deal of the Roosevelt administration. And what they did is they used social science tools basically to describe the state of affairs in Indian America at that time. And that include everything from the management of tribal property to the way personnel were hired and the quality of personnel in the BIA, tribal income, from agriculture, native products, and they examined family life. They really went and did a very deep sociological study. And that really, that study included many, many interviews with Indian people. So it was not only the academic kind of study, part of it, social science, but it was from the words of Native people, that this study was formulated, had such a big impact. You can see the thread of that in all the essentially the offer of proof in the Tlingit Haida case, because it looks so similar. That proof was a complete analysis of our people at that time. And it went from everything from the economy to land use to property rights to the importance of culture in the daily life of Native people. And it also laid the foundation for the analysis about Aboriginal title and all of the decisions that were made when the court found liability, I think are extremely important. And then there's really a third thread of this in the Alaska Native Claims Settlement Act. In that case, the United States Senate commissioned a report on the Federal Field Committee called Alaska Natives and the Land in 1968. And it just looks remarkably familiar, to the way and the findings and the analysis that was made in the Tlingit Haida case. And so Alaska Natives and the Land studied basically all the geographic areas in Alaska, the cultures, the demographics, including health and education, and the terrible state that it was in, still is in many areas now, how much money was being spent, the programs that were there, but most importantly, the reliance on the land for customary and traditional foods, and the necessity of how much land is necessary in order to have a sustainable economy in the rural parts of this state. So at least as I look at those two essentially studies, they're worthwhile to keep looking at because I think they've aged really well in the sense that they're still relevant today as they were at the time. The other issue that at least I found really quite interesting in the Tlingit Haida judgment, that is a piece of it, is the question of who's an Indian tribe. The federal government, has always used this definitional thing, for who it considers a tribe, but for both the benefit of Native people and also to exclude from benefit Indian people. And you can see that in the judgment because of this discussion that I'd already described about, is the Tlingit Haida Central Council a tribe for the purposes of receiving a judgment award, even if they said, well, you can file a suit, but you may not get anything out of the whole thing. And I thought that was particularly interesting because it does lay, whether it was by design or it just happened, what exactly exists today is that Indian tribes in Alaska are Indian tribes and Native corporations are both designated as and recognized as Indian tribes for the purposes of some programs and benefits and not others. And so here in the region, the reason this occurs is that Congress recognized tribes, and they also allowed the creation of tribes under the Indian Reorganization Act 1937, and then the Tlingit Haida judgment is separate. Then you have Sealaska and the village corporations all created at separate times. Well, Congress didn't have a master plan, they just did it. And so it really means that what is left as a continual discussion about, who has what responsibilities, who's an Indian tribe for what purpose, and that discussion, just continues on. In closing, I wanted to say, I think that the Tlingit Haida case was successful on its own terms. It really showed the power of self-determination and leadership in a situation where, you think, how would this actually happen? Because as I was thinking back on this stuff of hiring lawyers, to try to represent an interest, and anybody going to Washington, D.C., because 1929, you had to go to steamship, to go get to Seattle, then you had to take a train, and who knows how many connections and costs it would be to, get out there and how long it would take. There's none of this, nonstop from Seattle to Washington, D.C. on Alaska Airlines. It just didn't exist at that time. So it was really quite a remarkable feat to think that far out of the box, to be able to accomplish this. And I think the Native community learned, what was required from a political and legal standpoint, and all of that really did flow through the Alaska Native leadership that led to the Alaska Native Claims Settlement Act. So I think both Tlingit Haida and Native leadership were ANCSA. They're really quite remarkable innovators, and it is really quite something to look back and see what they all did. Thank you very much. Kanishtish. Do you have comments or questions? Yes.
Thank you, Chris. Well, first of all, thank you for this great presentation. I've always thought that we had to do a lot more analysis of this case, and I think this is a really good step towards that. But there's one thing that I know it's bothered you and I, because we've always talked about it, and I think we were youngsters when ANCSA was, when we were working on ANCSA, and we always talked about fisheries. And it was, to me, that the Jurisdictional Act recognized fisheries as a resource, something that should be compensated for. But then when it came forward, we were not compensated for fisheries. But then yet, when I think about subsequent laws and subsequent cases where fisheries or water rights are recognized, and I know that we've gone back right now in ANCSA to look at the landless communities, and I keep wondering, because I don't feel like resting that we lost a very valuable resource that Congress initially recognized, and I keep wondering, is there any kind of resource? I mean, obviously we didn't have an appeals court for court of claims, but it seems to me that was such a grave injustice, to the people of Southeast. And you're absolutely correct in terms of the Jurisdictional Act, the research that they did. I mean, I always go for a lot of information that's not available in general ethnographic and historical records. But the whole thing of fisheries is, I keep wondering, is there any kind of resource that you might think of? I think about, I don't know what, the outcome of Edwardson v. Morton, and then we had another case in St. Lawrence, I can't remember that case. And then I know we've been looking at the Dakl'aweidí, their water ownership that wasn't considered. So I just keep wondering, is there any way if you might think that we could bring that back.
Well, I haven't thought of anything other than, being able to essentially buy back permits that exist. That's a possibility, because we did look at this, and it is remarkable how concentrated, these permits. I think it's like about a dozen people in all the black cotton in southeastern Alaska. So there's that. The other thing, so far as the last Constitution is concerned, the limited entry fishery permits, was really an exception to the Constitution. So it really allowed that entryway that, has ended up being a barrier to people in villages to be able to utilize the resource. Because you don't have a permit, can't do it. You gotta, that accounts for the fact that, most of the permits now owned by Native people are really hand troll permits. They're the least valuable, of all of them. But this takes a lot more thinking, I think, because I think there is got to be a way to be able to do that. One thing I would say, though, that in terms of what existed at that time was the power of the fisheries industry is kind of hard to really conceptualize today. I can just date myself enough to have been, fish on my dad's boat before statehood, and when all you'd see these traps, and you'd see all the fish coming out of the traps. Well, the companies behind them were very well connected with the Department of Interior at the time, and basically it seems to me that had to have some kind of impact insofar as the way the Court of Claims, looked at this, because they were like oil companies today, I think.
Chris, if the settlement, Tlingit Haida settlement hadn't occurred, is that a precursor to ANCSA? I mean, is that a fourth step, or ANCSA would have probably occurred with or without the settlement?
Well, I think it probably would have occurred. The common thread between decisions that the Tlingit Haida leadership had to make at the time is very much like what the Alaska Native leadership was faced with on December 18th, 1971. What do? You get to this far, and you do this or not do it. Well, the judgment was made at the time, and it's a hard place to be, because, as the landscape's littered with people who didn't accept a congressional settlement or a congressional deal that they said was terrible, and then they find out they can never get it again, because that does happen. So I think those were hard decisions, they made them, but it seems to me that in the course of time, the biggest change, of course, was oil, but after that, insofar as ANCSA is concerned, we can probably thank the civil rights, all the activity that occurred at that time for justice, in civil rights for African American people and stuff, for creating an atmosphere that was very different from when the Judgment Act was being formulated and as it moved along. Because remember, 1959 was 55, was really the heart of termination as a federal policy. I mean, they weren't going in any kind of direction to any cede land back. They were trying to get rid of tribes on a very structured basis. Yes?
I guess what I've always found amazing being the decision was, like you were saying, all the social science, all the background information was brought in to establish Aboriginal title, how that concept was so well developed, formulated through that decision that, throughout all the treaties in the East Coast and all the way across the country, there was never really a formulation of Aboriginal title in the treaties. They sort of acknowledged
Yeah, it really did, and I'm really glad that Walter Echohawk will be here to talk about the Teton case, because it's like a sideboard, that for the court to be able to say that, you don't have Fifth Amendment rights for this land, so it's part of that discussion which occurred in the middle of this discussion. So the positive side was that, what you described. The other side of it was recourse. Yes.
How about the approach of not going for reservations? You mentioned that one of the first things that Tlingit Haida did was the contracting to basically supply some of the area for education. That seems to be a strong, particularly law enforcement against reservations as a form of settlement as well. Is that the case, or would there other legal issues around reservations that make it impossible to consider that if we were jurisdictional act?
Well, villages did seek reservations and did get them, and of course they were all taken out and essentially repealed as a consequence of ANCSA. But I think it kind of, punt on this in a sense, because it seems to me it's almost a separate study about, the impetus for not having reservations under ANCSA, because some of that came from the Native community, some of it came from, Congress and the people who represented us, at the time. But I think ultimately it really had more to do with the issue of hunting and fishing, jurisdiction, because if you have reservation, what comes with it is the right to hunt and fish. And, you can't help but see the great emphasis in the Court of Claims decision about fisheries, was they came at it every which way to make sure that, there wouldn't be any fishing rights, every kind of argument they could conjure up that these would not exist. Because I think a lot of it's tied to that. Yes.
Do you know who are the authors of the Jurisdictional Act?
I don't know. I understand Judge Wickersham was a key part of it, but I don't know who actually put pen to paper for that.
Well, maybe, anybody have any other pressing questions?
Thanks, sir. Thank you, Chris. I just would like to piggyback off what Rick had mentioned earlier. If it wasn't for our tribes to make the move and provide sovereign rights that we have now, I think in my view, there was like a leverage for ANCSA to be developed, even though our corporations don't have that sovereign right, but our tribe entities do. So it was a trade-off. It became a trade-off. It was a sacrifice, to formulate ANCSA and to help have control of our lands and to hold security for the native population, for our people. So I just wanted to make that comment, and I really appreciate you being here today.
Yeah, thank you. And your comment, I think, really does, mirror very much what some of the leadership that I've spoken with talk about the deliberations in regard to the Claims Settlement Act, because it's always kind of like, well, why do you leave subsistence on the table? Why didn't you resolve fishing rights? They were taken away. But what I've heard consistently was really a bandwidth issue. There were so many things to deal with, and their job, as they saw it, was to get as much land as they possibly could, and they got it to the 44.5 million acres. There was 60 million on the table. They were trying to get that, and as far as they're concerned, the whole ball game was really in taking care of that one issue. You could take care of the other problems later, but we're at the later, and it's still, these are still, difficult things to deal with.
it just always lifts me to think about you and growing up here in Juneau in an Indian village, and it just really raises up us all to know that your leadership has impacted us.
Thank you. Ashish.
Just one other comment. I always wanted to say is that 2 million acres that was left on the table just happened to be Chilkat, Kwan country, and Yakutat Kwan country, so.
Yep.
And we never say that, we're always so respectful to other people, I never say that was our bad.
You can say it respectfully. Well, thank you again.
Thing is, actually two things. Is, you got people in the room, remember, the first leaders is 17. So don't be careful of doing it. There's a little brochure out there of the subsequent lecture series. Don't be foolish like me, like Alan and Long, and then realize that they're on Tuesday, Thursday, and Wednesday. So the dates are always around a little bit. So don't try this simple rule. Other than that, thanks for coming.